Mr. Thompson is to pay $2,000 per month in spousal support. Meanwhile, he's going to concerts, he's going to baseball games, he's buying himself guitars. It was undisputed several months ago, Mr. Thompson is earning about $10,000 per month, is spending his money on things that are completely inappropriate and completely frivolous.
I don't make $10,000 a month.
I have this on as a show cause and contempt motion. Mr. Thompson, have you received those pleadings?
Yes.
Okay. And I assume that you are disputing.
I don't have the money to pay for it. I'm currently going through a bankruptcy.
Okay. All right, Mr. Zandy, go ahead.
And thank you, Your Honor, on behalf of the petitioner, Mariana Thompson, I am bringing this motion for contempt. Here, unfortunately, only a short time after the temporary order was entered in this matter back in April, and already we have very blatant, intentional, and willful violations from Mr. Thompson. This is a case in which Judge Basher heard arguments last spring, entered the order pursuant to the incomes of the parties based on the requested relief of my client at that time, and specifically ordered several things, and some of them are garden variety restraining orders, others are pertaining to the maintenance, and unfortunately, Mr. Thompson almost immediately began violating those court orders. I'll start in the order they were presented in my client's motion. First and foremost, related to paragraph 5 of the temporary order, it states very clearly that Mr. Thompson is to pay $2,000 per month in spousal support commencing on April 1st. So shortly after the hearing, he begins to become delinquent. Now, my client details for you that if she got paid at all, it would basically be in any amount that Mr. Thompson essentially wanted to pay. He would play off the excuse of, well, I have other things to buy. Well, I thought that was only a one-time deal, basically putting her off and putting her off. Meanwhile, he's going to concerts, he's going to baseball games, he's buying himself guitars. He's posting images of himself playing said guitars on social media, basically doing everything but paying and doing what he's supposed to take care of his wife a long period of time. So here we are now in August. He has failed to pay August, July, I believe June as well. Made a partial payment in May. Did pay the April amount as that was required by Judge Basher prior to the matter being heard. So by my count through July, he is $4,500 in arrears. And again, this is an order that is extremely new. So certainly it's willful, certainly it's intentional. If you go back and you looked at how we got to this point, this is a case where, again, it was undisputed several months ago, Mr. Thompson is earning about $10,000 per month. This is a case in which we initially had hoped that the parties would cooperate to file a joint bankruptcy, which was certainly on the table back in the spring. And we had detailed that to Judge Basher in our initial motion and declaration. And sure enough, we get no cooperation from Mr. Thompson. And although there's very little we can do about that, it's not part of the motion. That still kind of gives you an oversight of what the frustration is from my client. So basically his refusal to pay impacts the family home in Washington that she's living in. It impacts the insurance, her ability to pay bills. This is an individual who, without getting into the gory details, you saw this, is spending his money on things that are completely inappropriate and completely frivolous, all the while claiming to my client, well, I can't essentially afford to pay you while I'm having my fun and doing essentially what I want to with my $10,000 a month that I'm getting in earnings. So I think clearly that's willful, it's intentional. We're asking for a finding of contempt related to that. Moving down, again, the list, if you look at paragraph 8, this is the garden variety civil restraining order that's contained in probably 99% of divorce cases. Again, not unusual. Prohibits either party from selling or disposing or getting rid of any property. And what does Mr. Thompson do? Immediately after this order is reduced to writing and signed off by the judge, we start getting notices and concerns that he is listing community assets, including vehicles, on, I believe it was Facebook Marketplace or some kind of a social media site where he's trying to sell off the community property, again, in direct violation of the order. So as I advised my client, we'll reach out to him, and we did that. He took the post down for a couple of days only to put it back on and again tried to sell community property without the knowledge or consent of my client. and certainly in violation of the order, certainly in disregard to the notice that my office sent him. And he's at this point just kind of gone rogue, wants to do what he wants to do. There was a provision in the temporary order that he was to pay attorney's fees and costs in the amount of $2,500. To the best of my knowledge, he's failed to pay a dime towards that. He had 60 days to do that. We're well beyond that. And again, he essentially just decides he's going to bury his head in the sand and do whatever it is he wants to do. This is a problem. And we have zero assurances that he's going to do what's expected of him. He was at the hearing. He heard the ruling. He has a copy of the order. It's readily available to him. If he needs another one, my office is gladly email him a copy of that this afternoon. This needs to stop. He needs to be put on notice that he needs to comply with the orders, that it's an order, it's not a suggestion. He's clearly doing this intentionally. He's clearly doing this willfully, and he's doing this to the detriment of my client and her adult daughter alike, who still resides in the family home. Court is well aware, going through bankruptcy proceedings is stressful in and of its own. This is a case in which Mr. has essentially cleaned his hands of it. He now lives in the Midwest. He lives with his sister, or did. Understand he's now in a duplex. Nonetheless, he has the financial means and resources to do this, but sadly, he would rather spend it on frivolous things of online pornography, in addition to concerts, guitars, sporting events, and the like. And although he flaunts those on his social media, along with the attempts to sell community property, he has no interest in paying my client, and will give her literally every excuse in the book. My suggestion is we enter a finding of contempt today for the two violations. I'm not including the attorney's fees and costs. I'm not including anything related to the bankruptcy. We're asking for paragraph 5 and paragraph 8, specifically the court to find violations on that. We're also asking the court for a review date. And this is a case where my client absolutely cannot afford to spend precious money and time in having me come back and, again, as I say, babysit this case to ensure compliance with the opposing party. I do think this is a case where if we set a review out a month and a half to probably early October, send a strong message to him today, and that if he is not compliant, he is not current, he is not making efforts, he continues to violate the orders, that he will be in jail, that a warrant will be issued, and that it will require him to come back to Washington State. I think threatening his liberties and threatening his freedom will probably be the only impact that he has right now. Meanwhile, my client continues to struggle. She continues to try to stretch every penny she can. And again, that is growing increasingly difficult, as well as his delay in cooperating with the bankruptcy. I think that's where we are at. I think that's what we're requesting. In addition to what paragraph 4 of my motion details, a judgment of $4,500 for past due support payments. Now, there is a typo or a glitch in that. It should not say from July 1st of 24. It should say from April 1st of 24 through the middle of July. Also asking for attorney's fees and costs in the amount of $1,500. Also for civil sanctions, which I think are certainly appropriate given where we're at. We're asking $250 each for each violation, which would be an additional $500 in addition to the 15. And again, just a very strong, poignant message to this guy that he needs to come to the party. He needs to participate in good faith. He needs to do what the court tells him, and that this is an order. Again, it's not a suggestion. That's where we're at. Now, that's the relief we requested. And given the circumstances, I think that certainly is justified by laws as it relates to civil contempts. Would submit to this court that I did not receive anything by way of response from Mr. Thompson. I don't know if he filed anything or if he's just appearing today. I would just raise a blanket objection to any information he tries to introduce today, if any, not be considered as it was not filed timely.
Thank you. And just to confirm on the dates of spousal support unpaid, the temporary order from June 3rd says payment for April 2024 is hereby acknowledged.
Yes, that was the initial 2,000.
Okay, so then your contempt request would be from May 1st.
Well, I usually
Forward.
take that just from the date of issuance of the order. I think it puts you in the same spot if
Okay.
it's May through July or whatever the case may be.
Okay,
We just need that start date and that end date, but I think it puts us in the same as far as the judgment's concerned.
okay. All right, Mr. Thompson, are you able to hear the court? Okay, did you, just checking in, did you file anything?
No, I don't have an attorney.
Okay. I am gonna kind of limit your argument here. We don't do trial by surprise in Washington. So, what I take into consideration typically always needs to be provided to the other side first. But let me just ask you briefly, have you made any of the payments for spousal support since May 1?
I made $1,500 payment in May, and I've
Okay.
also made payments on the insurance,
Payments on what
the
insurance?
State Farm insurance.
Okay.
I just recently did that.
Okay. So what about the other support payments?
I don't make $10,000 a month. I only bring home about $7,500. So I don't know where he's getting that. I have rent to pay now. I am currently going through bankruptcy, and all the concerts and everything were paid for by my sister, not by me. So I'm struggling just as much as she is, and that's why I have filed bankruptcy. And I tried to do it jointly with her, and every attorney that we contacted pretty much told us not to file, or that I contacted anyway, told us not to file it jointly. So I was trying to go by the ruling that they had presented before about trying to file jointly, and the attorneys that for the bankruptcy are telling me not to file jointly. So I went ahead and did it on my own.
Mr. Zandy.
Yeah, and just briefly, my understanding is he's made one insurance payment to State Farm, and that was very recently. I think that was only since he was served with this, and that's kind of a moot point anyways, since he's required to pay for the auto insurance under the same existing temporary family law order. So the fact he didn't pay for May, June, and July would be another contempt. And again, we didn't make that part of our motion, but that it kind of undermines the argument there. As it relates to him struggling just as much as my client is, again, that's just not borne out by the information. Court set the incomes back in the spring with my client at $3,734 net per month, and Mr. Thompson at $6,838. And if you listen to the comments, he says he takes home about $7,500 a month. So that's another $700 or so more than the court set him at back in the spring at the hearing. So the fact he's making more now than was contemplated by the court, again, I think flies in the face of his argument that he's struggling. Reality is this is a court order, regardless of what he wants to pay or thinks he can afford, regardless of the fact that his sister or his family is spending significant sums of money so he can attend concerts, his money that otherwise he should be spending on giving that to his wife. Again, he has rent, my client has a mortgage. He has payments, my client has the same, but she's doing it literally on half of what his income is. So again, I didn't see anything in his argument that clears him from the willful and intentional violation. Again, as is unfortunately common in this case, it's been one attempt at an excuse after another, which doesn't hold any water in these circumstances. So we do believe that the request that I requested, the relief we requested in our motion, again, through my arguments, makes the most amount of sense. And putting him on a track of a review again in early October to make sure that he's doing what he can is likely appropriate.
What about his statement that he's now filed for bankruptcy? Do you have any information about that?
Well, I think if it was related to debts, and that's where it would get sticky. Now, once they file for bankruptcy, my understanding is the divorce action is stayed as it pertains to those debts. This is not related to the debts. I think anything support related, parenting plan related is still fair game. And the fact that he owes spousal support in the amount of $2,000, the attorney's fees previously ordered of the 25 doesn't apply to that. I think it's unaffected by the bankruptcy. So I don't think that again carries any weight related to that. If this was before you on something pertaining to the debt, I don't think we could raise that issue.
Okay. Mr. Thompson, when did you file for bankruptcy?
A week ago.
Oh, okay.
And I don't know that he's filed for bankruptcy. I think he's spoken to a bankruptcy attorney. And if I'm incorrect, please provide me verification to that end, Mr. Thompson.
I will.
Okay. Do you have any bankruptcy orders approved by a court at this point?
No, I was waiting on documentation from my wife because I didn't have access to one of the banks that I needed documentation for one of the cars, which has since
Okay.
been repossessed.
Okay, so there's nothing in the file, but taking your word that you may have filed for bankruptcy a week ago, I do find that I'm able to move forward on the contempt. I am going to approve the contempt finding and order as proposed by Mr. Zandy. I do believe, based on the record in front of me, that you have the ability to pay these amounts and have had the ability to pay these amounts since April, that you have willfully declined to do so in lieu of other endeavors. So I will issue the $4,500 contempt finding for back support, attorney fees in the amount of $1,500, and civil sanctions $250 each, for a total of $500 in civil sanctions for the two parts of the temporary family law order that Mr. Zandy has asked to be enforced today. I'm going to be careful with threatening jail at this point, but I will set a review in October. And I want to be very clear, Mr. Thompson, that that things like jail sanctions are on the table if we get too far down this contempt road and there isn't effort being made.
I don't know what I'm supposed to do. I can't pay it.
Okay, let's set a review for October 8 at 1 o'clock back on this docket.
And what are we doing with presentations, Judge, for you? Are you gonna pop in?
Yeah, I could pop in on a Tuesday, 1 o'clock. So what date do you want to put that on? And I'll let Jalen know.
Let's set it to September 3rd at 1 o'clock. Would work for me. That'll give me time to draft that, get it to Mr. Thompson, and if he has any objections, he can make them.
Okay, so Mr. Thompson, you're going to get a proposed order that you won't be asked if you agree with my decision, but you'll be asked if you agree that the order properly reflects my decision I've made here today. If you have any objections, please get those filed and be back on docket September 3rd at 1 o'clock. Okay.
Does the court want to set a date? Fees and sanctions and judgment are paid by, or do we want to leave that open-ended to 12% interest rate?
Let's.
What I don't want to have happen is he wraps all of the fees that he's been paid, ordered to pay, as part of that bankruptcy, which I can see happening.
Yeah.
I think we also turn the language that it's support somehow related, so we can't do that.
Yeah. Do you want to put a pay by date in there?
I think I mean, again, he still has made no effort at the initial 2,500 and the meter continues to run. I would say within 30 days.
I think that's, the court will adopt a 30-day payment.
It's not going to happen. I can't do it.
Okay, I'll sign that order, or I'll see the parties back on September 3rd to sign that order.
Very well, thank you.
Okay, thank you.
The defendant asked that post-majority support be ended. They ended up ending that. And without that funds, now I would like to have a review of spousal support that was ordered. And I would like to have filing status, tax filing status.
I have not missed any of the child support payments. I am in extreme financial distress at this point in time.
Let a lot of this go because of the post-majority, but when he entered to have that terminated, I